Hello everyone, my name is Orlando Scarcello and I'm a postdoctoral fellow at the University of Leuven. I want to thank the editors of Diritti Comparati for this opportunity to advertise my book, Radical Constitutional Pluralism in Europe, just published by Routledge. The book is available both in paperback and in hardback immediately, by the way. In it, I try to tame one of the great questions of European constitutional law, specifically, how it is possible that the law of the European Union and the law of the member states coexist simultaneously with no subordination of one level to the other. Indeed, if you look at the case law of the Court of Justice, you will find that, according to the Court, in case of conflict with national constitutional law, it's the constitutional law of the member states that must be displaced, while most of the constitutional courts and Supreme Courts of the member states say the opposite. But we study in law schools that, after all, law is organized as a pyramid of norms with a constitution on top. So how is this situation possible? This is made even more urgent by the fact that the two layers are indeed constitutional layers, in a sense that the law of the European Union is committed to the principles of modern constitutionalism, separation of powers, guarantee of rights, democratic governance to a large extent, and this has been recognized in the last few years even by Supreme and constitutional courts. The way in which I try to answer these questions is by looking at the theory of radical pluralism. Radical pluralism was developed in the first place by Neil McCormick, the intellectual father of European pluralism in the early 90s, in the aftermath of the Maastricht Treaty. According to McCormick, in those essays, various legal systems can coexist simultaneously with no subordination, sovereignty can be shared, and, in case of conflict, political negotiation solves them. McCormick didn't develop his argument further. He abandoned the theory of radical pluralism, as I explain in chapter 3 of the book. Those who followed McCormick agreed with him in dismissing radical pluralism. Actually, if we look at the existing literature on the topic, it can be divided into two main groups. On the one hand, there are those who claim that there is no such thing as constitutional pluralism at all. They argue that it is just an oxymoron, for sovereignty belongs to the states. On the other hand, there are those who not only consider it to be appropriate from the descriptive point of view, but also praise it normatively, as they consider it to be the most modern instantiation of constitutionalism, since it divides power between a supranational and a national layer. I try to navigate in between these two positions by revitalizing radical pluralism. Indeed, this is the first monograph entirely devoted to it. I agree with McCormick's claims from the early 90s that there can be coexistence between several constitutional layers, that sovereignty can be shared, and that conflicts are structural in the law. They will be eventually sorted out, for the most part, by a political negotiation. I argue that constitutional conflicts are part of the physiology of constitutional law, not of its pathology. They might become pathological only under extreme circumstances, when they touch upon the basic principles of the legal community, or perhaps when they are long-lasting, or both simultaneously. I take a positivist perspective in the book, in a sense that I consider the law to be a series of social facts that can be scrutinized without endorsing them, and I gather evidence from comparative law to sustain the thesis advanced in the book. In particular, in chapter 4, I look at evidence from American federalism before the Civil War. I look at cases in which American institutions, state courts, and especially state parliaments issued statements that we would call ultra vires, as they declared that federal powers had gone beyond their constitutional attributions. By scrutinizing these cases in detail, I argue we can realize that they were eventually sorted out by a political negotiation. I also look at cases coming from states, modern states, also unitary states with a single constitution on top, really, and argue that even there you have constitutional conflicts deriving from diverging interpretations of the constitution. Conflicts are even there sorted out via political negotiation. Lastly, in chapter 5, I analyze the existing ultra vires conflicts in Europe up to this date in 2023. I look at the Landova case from the Czech Republic in 2012, the IUS case from Denmark 2016, the PSPP judgment by the German Constitutional Court in 2020, and finally, the K321 judgment from the Polish Constitutional Tribunal of 2021. As the book was handed over in June 2022, there is no discussion of the motivation of K321 as it was published only in November 2022, 1 year after the publication of the judgment. Yet, I compare these two cases and argue that there is at least one fundamental difference between the three. Indeed, among other things, the Czech, Danish, and German institutions cooperated to solve the conflict politically in the aftermath, something that is not clear when it comes to K321 case. This means that the first three might belong to the physiology of European constitutional law, while the latter might well belong to pathology. In a nutshell, the book focuses on the structural role of conflicts, disagreement, and politics in constitutional law, and argue that this is not so much different from the role it has in modern states. Unions of states like the EU and states might actually be closer than we imagine.